Does privatisation address the problems of imprisonment? Hello, this is Simran Katani, and today you'll be listening to a criminal justice, sentencing and penal system podcast on whether the prison system should be reformed. So we start off with the Wolf Report in 1991. So this report suggests that one of the main problems of imprisonment is poor physical conditions in prisons, meaning many prisoners are not treated with humanity and justice, leading to further feelings of dehumanisation and consequently reoffending. Recently, the Bromley Fact File in 2019 stated that almost 70% of prisons in England and Wales are overcrowded. And the British Academy added to this view, revealing that 67% of people sent to prison in June 2019 did not commit a violent offence, yet 46% were sentenced for 6 months or less. These academics argue that these offenders should face financial and community sanctions rather than custody, as often imprisonment can lead to further reoffending. For instance, the 1991 to 1995 STOP programme found that 35% of offenders sentenced with community penalties reoffended, whereas this was 49% of those sentenced with custody. Liebling's review in 2014 of the MQPL survey suggests that better scores on this survey are significantly correlated with better reconviction scores. Organisational respect, or a lack thereof, conveys an implicit message to prisoners about how staff judge and value them. So due to overcrowding, staff are unable to fully cater for the needs of each prisoner, causing resentment of the justice system and subsequent reoffending. I'm going to argue that privatisation does not address the problems mentioned, but if anything, exacerbates these problems further. So firstly, in terms of the outcome of imprisonment, I argue that privatisation does little to combat the problem of higher reoffending. So some proponents, like Tanner, suggest that private prisons are better at reducing reoffending. And this was based on his study of 12 private and public prisons, finding that 7 of the private prisons had better reoffending rates than their public counterparts. However, I would argue that this is insufficient data, and nevertheless, the margin of difference is very small, at 7 to 5. So other advocates of privatisation may consider the advantages of innovation that private companies can bring. So these companies can use economies of scale to reduce costs and invest in innovative solutions to improve the infrastructure and operation of prisons, as companies will be incentivised by profits and remaining competitive against other companies. So this may improve the standard of prison life. However, Easton and Piper suggest that free market competition may not be guaranteed, as the company that wins the initial contract is likely to dominate the industry, potentially creating a monopoly and deterring other companies from entering the market. So the incumbent company would have the power in deciding whether to invest in innovation or instead just absorb the profits. Sparks draws on the reality that investors in private prisons will not commit capital unless there are prospects of growth and returns. Lilly and Nepper further point out that the construction of new prisons is the most profitable sector of the business. So this is creating a market of prisoners where a level of prison population is required to keep this industry from profiting. So in the long term, private companies' focus is not on preventing reoffending, but actually ensuring there is a sufficient supply of offenders and prisoners to ensure investors are profiting. In contrast, the public sector's emphasis is on maintaining social welfare rather than profits, making the state better placed to address the problems of imprisonment. Issues of reoffending are also linked to overcrowding, an issue that prisons are increasingly facing since the privatisation of prisons. The provisions for contracting out prisons were introduced in the 1991 Criminal Justice Act, and those for contracting out parts, function and activities of the public sector prisons in the Criminal Justice and Public Order Act 1994. So after these acts, the prison numbers soared, an increase in annual average growth rate from 2.5% in 1992 to 4% post-1993. There is an obvious link between this and the privatisation of the prison services. Easter and Piper note that privatisation has also led to a lower staff-to-prisoner ratio, which has safety implications within the prisons, and there's also a lower staff retention rate due to lower wages, which are offered by private prisons. the Prison Service Pay Review Body found that in 2006, the turnover amongst prison custody officers in the private sector was 27% compared to 8% in the public sector. So insufficient staff are unable to control the prisons, and this can make private prisons more dangerous. For instance, Sparks' study of Albany Prison has strict discipline measures compared with the more permissive Long Lartin prison. But this revealed that although there was more freedom at Long Lartin, there were far more unexplained head injuries. This shows that without a certain level of control and discipline, prisoners may get away with hurting each other, creating an unsafe environment. For example, at private prisons where staff retention rates are low and there is thus less control. So the motives of public prisons puts them in a far better position to increase welfare of prisoners and address the problems of imprisonment rather than private prisons. On a more normative level, it's argued that private prisons are less likely to be seen as legitimate, both by prisoners and the public. Liebling notes that there is research suggesting staff in private prisons treat prisoners with more respect than in public prisons. However, Hedemann is concerned that the market nature of private companies means that offenders are dehumanised as they become a means to an end, which is the profit. So as the prison service exists to restrict liberty, these restrictions to fundamental human rights should only be carried out by the state on a normative level. Given that private companies are not only administering punishment, but also allocating punishment in the form of allowing privileges, issuing sanctions, and putting prisoners in solitary confinement, there is a large scope for potential abuse where the primary focus is on profit margins rather than welfare. This view is supported by public opinion. The Howard League for Penal Reform found that 50% of the public are uncomfortable with the notion of private prisons, suggesting that the use of contracting out in this sector lacks legitimacy. Robinson notes that many prisoners also believe that private prisons are less legitimate, and this is a more significant viewpoint, arguably, as prisoners are the individuals that are affected most by the prison service. So with a lack of legitimacy, as well as being unable to meet the same outcomes as public prisons, privatisation of the prison service would not be adequate to address imprisonment problems. So to conclude, privatisation of the prison service does not sufficiently address the problems of imprisonment, but for many of the problems only exacerbate them. There is a tendency for private prisons to either do very well or very badly when run by the same company. This suggests that although in many cases private prisons perform well, they can also perform very badly if they are run cheaply, creating private prisons which are more dangerous and chaotic than public prisons. And due to the need to keep costs low, it's more likely that the latter situation might arise. So this, along with the reality that private businesses will always need prisoners to be in their prisons, this disincentivises efforts to prevent reoffending, therefore meaning privatisation cannot effectively address the problems of imprisonment. Thank you.